It is an honor to speak with you today. I've had a chance to be at each of the NASBA International Forums and the important evolution of development with regard to our common understanding of accountancy regulation around the world. It's also a privilege and an honor to be able to share this program with Bree, who's worked with me for a number of years in accountancy regulation, is an author in her own right, having had published parts and articles of books and such. So particularly pleased about that. Bearing in mind that I am the father and have some command power over situations and a little bit of insight, I have to take advantage of the moment. The awkwardness of this is that that's a picture of me. You've been playing with my slides. Ow. Okay. Well, we'll move right along here. Rather than a world report on a legal update, I want to focus on one problem. I want to assure you that the sky is not falling over this one issue. I want to identify it, use it as a teaching example, and put it in perspective, and then talk to you about how we can find some least disruptive, common sense, international solutions to the problem. The issue in part is that foreign unregistered firms are performing audit work for publicly traded companies headquartered in the United States. The problem can be defined in broader terms. It could be that they are doing other types of work, but let's focus for a moment on the most critical reserve service, the audit work, and let's talk in terms of audit work done for, particularly for SEC registrants and what's going on there. I think that our reflex would be that there couldn't be much because we have a triple net. We have not only state regulation, but we have the PCAOB and the SEC and its watchdog responsibilities, PCAOB registration requirements, and then of course we also have foreign registration requirements at each end. But still, there seem to be, perhaps not the sky falling, but some clouds in that sky that we need to anticipate and we need to work with and be able to come up with some quick and common sense solutions. As Bill Tracy mentioned, in Texas, they've done some review with regard to the accountancy issues there, and in particular with regard to this issue of unregistered firms. And so I want to turn it over to Bree for just a moment to summarize some of the findings that y'all have made thus far.
Sure. Can y'all hear me okay?
Yeah.
All right. So Texas law requires that an auditor have a Texas firm license to perform attest services for a company that has its principal office in Texas. And by principal office, the definition in Texas board rules is the location specified by the client as the address to which the attest service is directed. And so what I went looking for in the SEC database is companies that have their principal office, which they have to disclose in their SEC filing, companies that have their principal office in Texas and that have a foreign audit firm performing their attest work, signing their report of their independent audit firm. So what we've got so far is we've contacted 21 foreign firms. Of those 21, 15 have signed a cease and desist order agreeing that they will no longer violate the law in Texas, and 4 have signed acknowledgement letters stating that they weren't breaking the law in Texas and they won't break the law in Texas. And then we're still in discussions with a few, and in the coming weeks we're going to be contacting 6 more firms. regarding cease and desist orders for those firms.
What about, did you carry that research forward and look with regard to around the country, other states, and what's going on there? You have rough numbers?
Yes, indeed. What I did beyond Texas is I really did not have the time to do a complete full look at all 55 U.S. jurisdictions like I did for Texas, but I can give you a picture of the situation, that there are 107 foreign audit firms that I found doing a test work in at least 40 different U.S. states, possibly more than 40. And the 107 audit firms are based in 20 different countries, and the individual violations, if you add it all up, is about 250 different violations in the 40 states, with about 350 U.S. companies that are exclusively being audited by foreign audit firms. And this is maybe just a fraction of what there actually is out there. Like I said, this isn't complete research, but it's a picture of it.
Some of the data that you were depending on goes back 5 years, so you're sweeping up.
Yes, in the past 5 years,
Right.
This is all.
My sense of the information that you've developed is that there are some different categories of types of issues that we have here. One is that there's a sort of a technical violation where you may have a multi-state or a multinational large firm that in fact has an office in another country, has an office in Texas, but the audit report was issued by the firm in the other country, rather than the firm in Texas. That'd be one form of, it would be a violation under Texas law. Not necessarily a violation under every state's laws, but that's one category. Then there would be the category, as I understand it, of small firms where it was a onesies or a twosies, where it was one could argue an inadvertent violation. Yeah. And then there's that third category where it may be in connection with, and there are different types of schemes involved here. There's a pump and dump, and there's a reverse merger if illegal intent is involved. First of all, what is your overall sense of the percentage of all that you found that might directly be involved in those illegal scam type of?
Yeah, with the caveat that I'm not a CPA, I'm an attorney, so my understanding of the financial data that I see is limited. My reading about pump and dump schemes especially, that you can look for certain hallmarks in a company's filing that will make it look like the company may well be a pump and dump scheme. A small share price, small sales, very small market cap, just a handful of employees, almost no resources, and yet are incorporated and are publicly traded, usually OTC. And so looking at that just for Texas, for the 21 firms that we found so far in Texas, they're auditing about 40 companies. And I would venture the guess that maybe 30 of those 40 companies sure look like pump and dump schemes. May or may not be, but they have the hallmarks of that. Of the 30 companies, the vast majority are also reverse mergers, which I assume y'all are all familiar with reverse mergers.
You want to just give a one-sentence description of a reverse merger?
What you do when you have a reverse merger, and this is for when you want to publicly trade on U.S. markets, although I'm sure it happens elsewhere, you start off with a private company and a public shell company, and you are owning both of these effectively. All of your assets are in the private company, and like I said, the public company is just a shell company, and you can get the public company traded on a stock exchange, skipping all of your initial SEC filings and disclosures, then have the public company and the private company merge, and then effectively your private company is publicly traded without any of the initial disclosures.
And there's at least some indication, or at least superficial indication that some of these may involve one or the other at least.
Yeah, I mean, it's doing a reverse merger is a good way to save money. It's not necessarily that you're trying to sneak in your private company, but it seems like a lot of the pump and dump schemes go hand in hand with reverse mergers.
So at any rate, there's some evidence that in some instances there may be more involved than simply a registration issue. It's going to be critical that we parse out the difference. For example, there are going to be companies that have all the earmarks of a reverse merger, and it's intentional and it's legitimate. Or there may have some of the red flags, the caution out there of a pump and dump, but they're not. It was not intended that way. It was just a startup entity or another entity that was going in that direction. So we're not jumping to the conclusion all of this is illegal in the sense of it's more than a registration issue there. But it does open the door to the potential for that concern. That would be if I were out there devising a scheme for one of those types of scams, implementing it, one of the things that I would do would be to try to avoid the registration requirements of different states in so doing. And then beyond that, not simply the registration issue, because you fix, often states, provinces will fix a registration issue by simply getting someone to register, fix it, get it to register if it's there. Some would even argue that if it's a multinational entity and there is a registered firm there, that the issue is not a registration so much as whether or not the report should have been issued out of the local office or not. Sometimes, and I have a hunch that the details will reveal that the inadvertence or the issuance that references a home office in Texas or whatever state, that may have been the client's doing rather than the auditor's doing as well. So there are different ways of looking at that. But there are potentially other violations involved because it comes to standards issues, how you reach that, an instance where there might be liability where the auditor is ignoring some of the obvious red flags, if it's bordering on or becoming illegal practice in another sense, or if there's some knowing participation in fraud or further conspiracy or wire fraud, mail fraud, or racketeer influence and corrupt organization instances. Now, where I want to take this in part is toward the UAA model. For those of you that are not in the United States, this will be a little bit of new territory. I know we've talked about it here at this session and at prior meetings of this group, but for the rest it'll be a refresher. But it's to understand just how you capture, how you deal with someone who is avoiding or evading your laws, be it registration, be it any of the other applications. And in the discussions, even in the breakout session, one of the things I caught as I was just listening was everyone starts with the example, what if you have a chartered accountant coming into my jurisdiction? What if you have a CPA coming into my jurisdiction? How do I get them to comply with my law? What do I do to them if I find they are violating my law? Ex-President of the United States, Harry Truman, had an expression I overly quote, but he said that you shouldn't tell anyone to go to hell unless you can send them there. And so in terms of enforcement, you want to be able to not only have rules out there operating, but you want to be able to follow through. You want to be able to make it stick. But we begin with some, I think, some misconceptions. Where the questions I was hearing were coming from was that notion of here is an auditor who is physically going to be in your jurisdiction. They are violating your law, aren't they, if they are doing work for an audit client who has a home office in your jurisdiction. But that's not really the whole picture today. As we heard yesterday, there's the second life, the avatars, and so this might be the picture of today's auditor. That is, it's just electrons crossing in, maybe entirely through email, through internet connections, some other form of communication into the states. Although I have to say that by analogy, it's not terribly different from telephone or mail in terms of how you have to think about it and whether or not you can, your board, you can subject someone from another state to your jurisdiction. So there are some, I think, some misconceptions amongst regulators as well as those who aren't regulated. This notion that there has to have been a physical presence in order to be able to enforce your laws. That there has to be a tangible license issued by your board that you can take away if they violate your laws. That consent to jurisdiction, consent to enforcement or to complying with the state's laws, that has to be in writing, that you have to have something signed by the auditor or by the firm, and that there must be actual service of process on the individual auditor or the individual firm. Those are not quite true in today's setting. I can't speak for every state, nor certainly every country, but the trend is quite the contrary, and that's in deference to the reality that practice is now through the internet so heavily. If you're sitting there and you're not closely paying attention to me, but you have internet right in front of you, just go ahead and Google your jurisdiction and internet practice, or internet audit or electronic audit, and you will be surprised at the number of firms that exist and are offering and rendering audit services, not just tax advice, not just business consultation, but audit, attest services into your jurisdiction without having any physical connection whatsoever. The key jurisdictional question that the courts have evolved and built upon, and this is not brand new, but it has been built upon, is this idea. What's the question? Did the firm, did the individual intentionally avail themselves of the benefit of the laws of your jurisdiction? And that does not mean that they had to cross the border or that they declared that they were going to do it. It could simply be that they were issuing a report in your state and that they could only be lawfully in your jurisdiction without formal registration by consent, that they consented to be subject to the laws of your jurisdiction. And that's really the key principle that the uniform accountancy was based upon. And I hasten to add that I think that is as good a model as I've seen for enhancing not only mobility but enforcement across national boundaries as well. You know, when Ken Bishop went around the country a few years ago and began, I think, with not only David Costello with NASBA, but also the AICPA, and a push with all the state boards, this what I call the mobility miracle. In just a few short years, we went from a handful to now 50, 50 jurisdictions, all but 2 states that have mobility. But the pitch was 2-part. No notice that you could go into another state, not only individually, but as a firm for certain purposes, for certain services, and you didn't even have to send notice, much less a fee. There were only certain times that you would have to register, and that you could do it without notice. But the other part of the pitch to the state boards and to the legislatures was no escape. We're going to need something of the same concepts there as we go forward. The mobility and cross-border enforcement enhancements in the UAA The UAA is available online. It's easy to find. This particular section, what I've highlighted, I think is most important, is that the individual using this practice privilege, meaning if you're a CPA in Michigan, you can offer or render services in almost any other state in the United States. And I would say if you're a chartered accountant in Canada and we got this to work internationally, you could do the same electronically otherwise. But you must render only certain types of services, attest services, through a firm that has obtained a permit. However, you go and you look further, and I'm going to touch on this. First of all, I just have to say that there's a reference here to home office. And Texas did not quite use it the same way that it was defined in the UAA, but a lot of states have varied from that. It probably tells us that we need to work on that definition of home office as to the client, as to where their home office might be. I suggest that we might want to go in the direction of having an home office that is defined more in terms of a filing. If it's an SEC registrant, then it's what they identify in their filing as their registered place of business. But if you jump from that requirement in Section 23, that you must do it through certain services through a firm, registered or otherwise, but then you look at Section 7, and it narrows it a bit. Only certain types of attest services actually have to be done by a firm registered in that state. If you have an office in the state, obviously you have to be registered. But if you're rendering audit services, you do have to register. And it does require that there be some compatibility with regard to the ownership requirements and meet the peer review requirements as well, and that the services are rendered by someone who qualifies individually to have practice privileges under the Uniform Accountancy Act. These provisions have actually been adopted in almost every jurisdiction to some extent, greater more than less, as a model for working. And what it means, if you want to look at the reverse end of it, is that someone could be offering let's say, certain types of attest services, compilations, without actually having to register the firm in that other jurisdiction at all. You can just offer them in there as long as you meet other criteria. For these purposes, I focused mainly upon the audit issue as well. Now, what does this mean in part? It means that there's a way to come in as long as you meet the conditions with regard to substantial equivalency, which are set out in Section 23. Those pertain not just to the individual, but to the firm that they are employed by. And then as a condition, and remember I said that it doesn't have to be in writing, this consent, as a condition of taking advantage of this exemption from registration, you agree that to the personal and subject matter and disciplinary authority of the board, that you're going to comply with the rules, that if you ever lose your license, that you and the firm no longer, they understand they can no longer practice in the state, and to the issue of service of process, how do you serve the notice of discipline on the individual or the firm, you agree to the appointment of the board in the home jurisdiction as a place where you can serve a due process for administrative purposes. This does not include civil private litigation. This only pertains to the board's authority, the board's jurisdiction, and the ability to reach the offending licensee or firm. Another feature, important feature of Section 23, prior to the mobility movement, the UAA was geared toward each state or province having to rely upon the home state's enforcement. And that was an imperfect model because the interest of the home state might be minimal because the harm was done in your state, not their state. And It may also be a problem because that state doesn't have the muscle, the resources to do as good an enforcement. So the UAA was reshaped to make sure that states, provinces could protect their own citizens under this model. But this provision does go on to say that if you violated somebody else's laws or rules, it's a violation here. And the UAA, which has this part, this last sentence, has been adopted in many jurisdictions, puts a direct onus on the board to investigate such matters. Now, brush through to try and identify, an approach that U.S. that NASBA and AICPA developed through the Uniform Accountancy Act. I regard it as part of a step in the right direction. I think another important part is going to be enhancing the PCAOB inspections, perhaps by simply asking the question, are you registered in the place where you are, where your client's home office is, or whatever the appropriate question is going to come up. I think, as I understand now, they only ask in terms of, are you registered somewhere? You've had, I think, a telephonic meeting, you in Texas with Bill, with representatives from the SEC. Are they sounding like they understand the problem and wanting to work toward improving it?
Yeah, from sitting in on the SEC call, they sound like they're in the preliminary stages of understanding the issue and looking into it. They are, separately from that, developing rules that would address this whole reverse merger problem, which could help. And same with the PCAOB, in the process of developing standards and also looking into reverse mergers and the audit firms that are doing the attest work for the reverse merger companies.
Okay, thanks. Another key is going to be greater bilateral cooperation in terms of an approach to problems like this and in terms of solutions. There are going to be enhanced state and provincial actions. Texas is a leader in the area, but not the only one that's looking at this type of issue. Other states have to. Ultimately, we have to work together to come forward with a common sense, practical solution, and making sure that we prioritize correctly and identify the inadvertent noncompliance and separate that from the truly bad people who are out there, some that are going to take advantage of a loophole in a system. And then, of course, I think voluntary compliance is also key. And my sense is that multi-state firms have been willing to work and cooperate in achieving a solution as well. In terms of other steps toward a better model, I think a key is going to be in the UAA. We need to look and make sure that we are properly defining for all practical as well as legal purposes what a home office is. We need to be able to look at the UAA and begin to think in terms of enhancing, improving, facilitating foreign firm mobility. There's an entire section of the UAA on foreign licensees and tremendous strides with regard to mutual recognition agreements. But do we need to take that further? Do we need to be able to enhance that? There are going to be some problems along the way, and ownership is going to be one of them. Cross practices with attorneys in significant positions in some of the foreign firms, as Jim Rigos pointed out to me this morning. One of the largest law firms in the world is an accounting firm in Europe. So there are going to be some issues we have to work around. But at the same time, can we work toward a better model? And then I think improving enforcement, not only federal to state or province, but also internationally in terms of cooperation as well. The whys, there are some very practical as well as some legal ones as to why this is important. For one thing, everyone's business, whether you are a direct regulator or part of a professional association or a practitioner, you have to be concerned that the qualifications, that the level of competence is high, that maintains the reliability, the public's reliance on the profession, that you want peer review. And yet, what we'll see is if someone avoids the registration of an individual state, it may be because they are not able to comply with peer review requirements. And yet we have firms in your state that are losing their opportunity to practice or render certain types of services because they are failing to comply with peer review. We don't want that entire system that works avoided by someone being able to filter in electronically from outside and avoid that responsibility. Fees are on the list. The states do have to operate with revenue. I don't think anyone's been pushing that as a number one, number two, or number three, but it is an element, and it is a concern. And then there's a fairness and equal treatment. You drop the hammer and enforce against firms within the state and yet not be able to do anything about someone who is practicing electronically or illegally is also a question of fairness, of equal treatment. There are concerns with regard to private jurisdiction, that is in private litigation. I would only turn that to say is that in other contexts we've said, well, some of these things can be taken care of because they'll just litigate it, they'll hire a lawyer and they'll fight over it. I think that the avenue there is less available as a practical matter, and that the focus has to be at the regulatory level. Otherwise, you run the risk of someone figuring out to make the private angle more and more available, and all of the problems that Rick talked about yesterday would be multiplied in terms of the potential for liability, as some are already there. They just know they need to file in the United States. And then because we need that regulatory, that public protection enforcement jurisdiction. And these are ways that we can work together to make this work on a broader scale. You know, again, if it's one state to another, that's one thing, province to province, yet something else. But if it's from another place entirely, we need to be able to do the best possible job we can to protect the public. And also, I think, continue to preserve in those who are trying to comply with the law, preserve in them the rights and responsibilities, but particularly the privileges that go with that job as well. I thank you for your time and for Bree's great help with this, and understand we are out of time.